So, Assembly Bill Alpha 6891, 2015 2016 legislative session relates to the removal of cases, contacts, and carriers of communicable diseases who are potential dangers to the public health. And we're currently at A416. I'm going to do an extended dive into this and go through each of these. Relates to the removal of cases, contacts, carriers, and communicable diseases potential, huh? And so this is introduced. Well, this is introduced during the Obama years. No Obama years by M. of A. Perry. Wow. Were ones that referred to the Committee on Health, an act to amend the public health law in relation to the removal of potential of cases, contacts, and carriers of communicable diseases who are potentially dangerous to the public health. I mean, well, what about needle shares, right? What about these freaking STD freaking ridden succubuses and incubi, that are spreading their, diseases. Anyways, the public health law is amended by adding a new section 2120. That's just kind of, if you actually look at that, 2120, when did the virus to start? 2020? And, well, I guess it kind of came out in 2019. Don't want to read too much into that, but, it's kind of peculiar. I don't believe in coincidences. Removal and detention of cases, contacts, and carriers who are or may be a danger to public health. Other orders. The provisions of this section shall be utilized in the event that the governor declares a state of emergency due to an epidemic of any communicable disease. Upon determining by clear and convincing evidence that the health of others is or may be endangered by a case, contact, or carrier, or suspected case, contact, or carrier of a contagious disease, that, in the opinion of the governor, after consultation with the commissioner, may pose an imminent and significant threat to the public health resulting in severe morbidity or high mortality, the governor or his or her delegee, including but not limited to the commissioner or the heads of local health departments, may order the removal and or detention of such person or of a group of such persons by issuing a single order, identifying such persons either by name or by a reasonably specific description of the individuals or group being detained. Such person or group of persons shall be detained in a medical facility or other appropriate facility or premises designated by the governor or his or her delegee in complying with subdivision 5 of this section. A person or group removed or detained by order of the governor or his or her delegee pursuant to subdivision 2 of this section shall be, explanation matter in italics underscored is new, matter in brackets is old law to be omitted, detained for such a period in such manner as the department may direct in accordance with this section, notwithstanding any inconsistent provision of this section. A confirmed case or carrier who is detained pursuant to subdivision 2 of this section shall not continue to be detained after the department determines that such person is no longer contagious. A suspected case or suspected carrier who is detained to subdivision 2 of this section shall not continue to be detained after the department determines, with the exercise of due diligence, that such person is not infected with or has not been exposed to a disease, or if infected with or exposed to such a disease, no longer is or will become contagious. Holy crap, this is such fucking gobbledygook. A person who is detained pursuant to subdivision 2 of this section as a contact of a confirmed case or a carrier shall not continue to be detained after the department determines that the person is not infected with the disease or that such contact no longer presents a potential danger to the health of others. A person who is detained pursuant to subdivision 2 of this section as a contact of a suspected case shall not continue to be detained after the department determines, with exercise of due diligence, that the suspected case was not infected with such a disease or was not contagious at the time, was exposed to such individuals, or after the department determines that the contact no longer presents potential danger to the health of others. Are you seeing like how many loopholes there are in this and how vague this is? This is like the Patriot Act. Well, freaking, I suspect this person might be committing terrorism because they are anti war, or what do you call it? Or, I don't know. Yeah, it just freaking, it's Patriot Act 2.0 fucking rhetoric. And it's like, and this is how freaking things work on a state level and then move up to a national level. And especially a powerful state like New York, yeah, there should be causes for concern. Excuse me. So where am I at? No longer presents potential danger to the health of a person who is detained pursuant as so have his or her medical condition and needs assessed and addressed on a regular basis and be detained in a manner that is consistent with recognized isolation and infection control principles in order to minimize the likelihood of transmission of infection to such person. Alright, so we can see that this was done April 8th, 2015. And one, can think, oh, that's Ebola. That's what this is talking about. Well, no. This is about tyranny. And so, I'm pretty certain that it's pretty much all the same. Alright, so be detained, and to be detained in a manner that when a person or a group is ordered to be detained pursuant to subdivision 2 of this section for a period not exceeding 3 business days, such person or a member of such group shall, upon request, be afforded an opportunity to be heard. If a person or group detained pursuant to subdivision 2 of this section needs to be detained beyond 3 days, they shall be provided with an additional commissioner's order pursuant to subdivisions 2 and 8 of this section. Oh, wow. So, not only that, but you have the opportunity to be heard, but upon request, they're not obligated. You got to request it. And basically, and they can extend it, the order to, what is it? In order to be, the delegate shall, hold on a second. Alright. So, they shall look for an additional commissioner's order pursuant to subdivisions 2 and 8 of this section. When a person or group is ordered to be detained pursuant to subdivision 2 of this section for a period exceeding 3 days, business days. So, yeah, you know what? Freaking, you got put in on Thursday. We're not getting out to Monday. Such person or member of such group. Wow, and that's the damn thing too. Group. Request release. The governor or his or her delegate shall make an application for a court order authorizing such detention within 3 business days after such request. By the end of the first business day following such Saturday, Sunday, or legal holiday, which application shall include a request for an expedited hearing. After any request for release, detention shall not continue more than 5 business days in the absence of a court order authorizing detention, notwithstanding the foregoing provisions. In no event shall any person be detained for more than 60 days without a court order authorizing such detention. Sorry, my fucking. Yeah. Anyways, the governor or my neighbors are fucking loud. And I'll put it to you this way. Freaking. It's very easy to stereotype. The governor or his or her delegee shall seek further court review of such detention within 90 days following the initial court order authorizing detention, and thereafter within 90 days of subsequent court review in any court proceeding to enforce an order of the governor or his delegee for the removal or detention of a person or group issued pursuant to this subdivision, or for review of the continued detention of a person or group, the governor or his or her delegee shall prove the particularized circumstances constituting the necessity for such detention by clear and convincing evidence. So, I mean, that's the thing, is that they can take you just on suspicion, and when you're in their custody, they pretty much have full rights of one's body. And, well, who knows what they... Oh, well, you're a potential health risk, and so we're going to inject you with this. Oh, wow. Now you're actually contagious. So now the law is on their side. So that's the thing, is like, they create this vague circumstance for them to get you in their system so that they can, hey, either comply, take the easy way out, just comply, listen to us, or be defiant and, well, we're going to, don't worry, we got you. We're going to reprogram you one way or another. We're going to break it down. So a copy of any detention order of the governor or his or her delegee issued pursuant to subdivision 2 of this section shall be given to each detained individual. However, if the order applies to a group of individuals and it is impracticable to provide individual copies, what the fuck? However, if the order applies to a group of individuals and it is impractical to provide individual copies, so now they're trying to conserve paperwork. They're trying to conserve papers. It may be posted in a conspicuous place in its detention premises. A detention order. Wow. Holy shit. If this doesn't scare you, I don't know what the fuck does. A detention order of the commissioner issued pursuant to the subdivision 2 of this section shall set forth the purpose of the detention and legal authority under which the order is issued, including the particular sections of this article or other law or regulation, a description of the circumstances and or behavior of the detained descriptions of the circumstance constituting the basis for the issuance of the order. The less restrictive alternatives. I'm sorry, I'm about to fucking slap this fucking stupid fucking hoe. Less restrictive alternatives that were attempted and were unsuccessful, and or the less restrictive alternatives that were considered and rejected, and the reasons such alternatives were rejected. A notice advising the person or group being detained that they have a right to request release from detention, and including instructions on how such request shall be made. A notice advising the person or group being detained that they have a right to be represented by legal counsel, and that upon request of such person or group, access to counsel will be facilitated to the extent feasible under the circumstances, and a notice advising the person or group being detained that they may supply the addresses and or telephone numbers of friends and or relatives to receive notifications of the person's detention, and that the department shall, at the detained person's request, and to the extent feasible, provide notice to a reasonable number of such people that the person is being detained. In addition, an order issued pursuant to subdivisions 2 and 7 of this section requiring the detention of a person or group for a period exceeding 3 days, business days, and he wants saying business days. He wants, so it's very easy. I mean, very easy for them to do freaking 5 days. Even 6 days because of holidays. Advise the person or group being detained that the detention shall not continue for more than 5 business days after a request for such release has been made in the absence of a court order authorizing such detention. Advise the person or group being detained that whether or not they request release from detention, the governor or his or her delegee must obtain a court order authorizing detention within 60 days following the commencement of the detention, and therefore thereafter must further seek court review of the detention within 90 days of such court order and within 90 days of subsequent court review. Oh my God. I mean, I have to reread this several times in order to understand it all the way. Advise the person and group being detained that they have the right to request that legal counsel be provided. That upon legal counsel be provided because someone was suspected that they were a potential health risk. That upon such request, counsel shall be provided if and to the extent possible under the circumstances, and if counsel is so provided, that such counsel will be notified that the person or group has requested legal representation. A person who is detained in a medical facility or other appropriate facility or premises shall not conduct himself in a disorderly manner, and shall not leave or attempt to leave such facility or premises until he or she is discharged pursuant to this section. Where necessary and feasible under circumstances, language interpreters and persons skilled in communicating with vision and hearing impaired individuals shall be provided. I'm glad they're, at least taking care of the disabled. The provisions of this section shall not comply to the issuance of orders pursuant to 11.21 of the New York City Health Code. In addition to the removal or detention orders referred to in any subdivision 2 of this section, and without affecting or eliminating any other authority that the commissioner may otherwise have, the governor or his or her delegee may, in his or her discretion, issue and seek enforcement of any other orders that he or she determines are necessary or appropriate to prevent dissemination information or transmission of contagious diseases or other illnesses that may pose a threat to the public health, including, but not limited to, orders requiring any person or persons who are not in the custody of the department to be excluded. Oh my God. To remain isolated or quarantined at home or at premises of such person's choice that is acceptable to the department and under such conditions and for such period as will prevent transmission of the contagious disease or other illness, to require the testing of medical examination of persons who may have been exposed to or affected by contagious disease, or who may have been exposed to or contaminated with dangerous amounts of radioactive materials or toxic chemicals, to require an individual who has been exposed to or infected with contagious disease to complete an appropriate prescribed course of treatment. Well, let's take a swig there. Prescribed course of treatment. Wow. Preventive medication or vaccination, including directly observed therapy to treat the disease and follow infection control provisions for the disease, or to require an individual who has been contaminated with dangerous amounts of radioactive materials or toxic chemicals such that said individual may present a danger to others to undergo decontamination procedures deemed necessary by the department. Such person or persons shall, upon request, be afforded an opportunity to be heard upon request. And once again, but the provisions of subdivisions 2 through 11 of this section shall not otherwise apply. This act shall take effect on the 13th day after it shall have become law, effect immediately. The addition, amendment, and or repeal of any rule or regulation necessary for the implementation of this act on its effective date are authorized to be made and completed on or before such date. Well, so, well, comments deemed off-topic, commercial, campaign-related, self-promotional, or that contain profanity, hate, or toxic speech, or that link to sites outside of New York Senate domain are not permitted and will not be published. Attempts to intimidate and silence contributors or, whatever. So, 122 write-ins. It's got 1.2. Wait. Five people freaking said it was good. Interesting. It's been introduced 7 times without much of the wording being changed, and in all its ambiguity, it mentions a couple of things specifically, which elicit the potential for detainment, contagious disease or other illness, and radioactive materials or toxic chemicals that was introduced well before COVID. So it's unlikely to be the initial motivator. That's saying COVID doesn't exist, never happened. Now research the laws and the bills hanging out in the legislation of other states once they have anything to do with terrorist attacks or if they exist. How do they differ from others? Do they also mention the contagious disease, radiation, toxic chemicals? See this Patriot 2.0. When were they introduced and how many times? I know our first instinct is to freak out, but just think for a minute and ask some questions to determine your next action. I'm not arguing one way or another, but perhaps this has to do with something entirely different from what you think on impulse. And that begs the question, should we be concerned about that something else entirely? Yes. I denounce all further restrictions placed on the people in the name of public health and decry all who do traitors to humanity. Quarantine is what happens when someone carries a deadly, high contagious disease. It's what people do when introducing new fish to the tank, to be sure. A valid point. The only squat on a PDF link. This bill is a no-go, and stop removing my comments. You remove my comment again. Overreach of power and control, not the future I fought for as a veteran, nor the future I voted for. Again, we matter, but go ahead. Remove my comments. Give me more proof of your corruption. Seems they have blocked the PDF download. I was able to see it. They cannot be serious. Live free or die. Yeah, indeed. I just own New York State. A big nay for me as well. This dangerous bill is not necessary, whatsoever, and is totally ridiculous. It's barbaric. This bill must not pass. Next, we the people must elect. Man, I'm telling you, freaking, there's some good people out there. So check this out. And very scary. Very scary.